extremely helpful.
Surprising.
My Lords, it's a great pleasure to follow the noble ladies Baroness Parmenter and Hayman and speak to Amendments 126 and 130, which they've so ably already introduced and to which I've attached my name, and both of which have the fullest and broadest possible range of support across parties and non-parties in your Lordship's House. And I essentially agree with everything the noble ladies have already said, although I would perhaps give the government rather less praise on what I would call its extremely limited measures of polluter pays that so far delivered than the noble lady Baroness Parmenter did. I think, going first to Amendment 126, Clause 15 has been described as the ministers can do whatever they like part of the bill. And I note the Peers for the Planet briefing, among others, I should declare my position on the advisory board of Peers for the Planet, says that the direction of travel of this bill is deregulatory. And we're hearing one set of rhetoric, but ultimately what we are talking about is the law and what will be written into the law. And that's what will hold sway, not fine words we might hear about a desire for higher standards. And I think it's also important to stress that both of these amendments are written and deal with what are environmental issues, but they're also very acutely human health issues. And look at the current parlous state of public health in the UK. We really cannot afford to be going backwards in any of those kind of areas. Now, I think what this amendment, particularly 126, tries to address is the fact that there are no non-regression clauses in this bill. This is, in one area, trying to bring in a non-regression clause. I would like a non-regression clause apply to every category, whatever a category is that this bill might identify. But at the moment, I'll stick with the things that are identified in these two amendments, at least as some kind of starting point. And I think when we come to Amendment 130, it's particularly clear that, and I think we had very long, hard fights in your Lordship's House, as I recollect, in the Environment Act of 2021, that we do have non-regression clauses. And there is also the power to amend what are we now calling retained EU legislation. So it is there in primary legislation. The power already exists with rules applying to it. Now, I'm not a lawyer, and I'm not sure if any of the lawyers currently in your Lordship's House can explain to me how you can have non-regression clauses applying to a set of regulations in one bill, and another bill has no non-regulation clauses. It depends which bill you use, whether regression or non-regression is going to apply. Let me guess which law the government's likely to want to use. Let's have a guess, shall we? So, I do particularly want to address, in terms of Amendment 126, and I'm seeking to add to rather than repeat anything other noble ladies have said, particularly focus on the ensuring that we do not conflict with relevant international environmental agreements. And I'm actually not sure in this, the way this is currently written, and indeed this is a fast-changing area. Of course, since this amendment was written, we have had finally, after 20 years of negotiation, very excitingly, the agreement on the High Seas Treaty. Now that is a real step forward. We also have a mandate for negotiating a UN treaty on plastic pollution. So all of these things, this is where a significant amount of environmental action is happening. We surely can write on the face of this bill to say we will comply with the international agreements that we have signed up to. Indeed, in many cases, we would claim to be, and in some cases are, leading. Now, it might be said, well, of course we don't need to do that, but if it's not a problem for the government, why can't we write it in anyway? But of course, many noble lords will have just picked up the legal migration bill, which has on the front of it a statement from the Home Secretary that reads, which says she is, quote, unable to make a statement that in my view the provisions are compatible with the Convention rights. But the government wishes the House to proceed, close quotes. So, my Lords, I truly believe we need written into this bill, every bill, perhaps, a statement that says we will comply with international obligations we've signed up to. Now, I finally want to get back to, and this is relating particularly to 130, and, well, actually both of these really, the non-regression elements, and the famous paragraph in the famous letter about overall regulatory burden and indeed what a category is. Now, it might be reasonably thought that a category of regulations might be plastics, regulations that apply to plastics. So I want to explore a little practical example of what these amendments could do to stop happening. We have actually seen, just in the last week or so, some really extremely disturbing research come out about the impact of microplastics. This is particularly what's been identified as a new disease of plasticosis. This has been found in the digestive tracts of flesh-footed shearwaters. It's only one seabird, but the experts all tell us there's no biological reason why what's happening to those seabirds is not happening to all of us. As we ingest, what research suggests is up to 5 grams of plastic a week that you could be ingesting, depending on your diet. Now, plasticosis, the reason why it's been given that name, is it's like silicosis and like asbestosis. It's an inorganic material that's causing irritation to biological tissues. This, my lords, is really, really serious. And I'll go to words published in the Times a few days ago, quoting Dr. Luisa Campasanalo, who's an expert in histology and embryology, who was speaking at the American Association for the Advancement of Science. We should not drink bottled water in plastic bottles. That is what someone who's looking at the tissues, at the damage being done, is saying. So let's imagine that the science gets stronger in the next year or two, and we can only see the direction the science is heading in. And we say we want to bring in an SI to end all use of plastic bottles for food materials and drinks. What could be the conceivable counteracting release of regulation? What would bring you to a balance of no greater regulatory burden? What would you have to abolish on plastics to balance that? These amendments make an attempt to deal with issues like that, my lords.
My lords,